morning. I'd like to call the Tuesday, February 14th, 2023 Board of Funeral Directors and Embalmers meeting to order. And Ms. Bohannon, if you'll call the roll, please.
Fred Berry.
Here.
Anthony Harris.
Here.
Tanya Scale Haynes. Chris Lee.
Here.
Scotty Porsche. Charles Rahm. Pam Stevenson.
Here.
Mr. President, we have a quorum.
Thank you, Ms. Bohannon. We have the agenda in front of us, and let's take a moment to review that and receive a motion to accept.
Motion approved. So moved.
Second.
All right, have a motion by Mr. Berry, second by Mr. Lee to accept our agenda. All in favor? Any opposed? All right. We also have the December 13, 2022 minutes before you. Give you a moment to review those. If there's any questions or additions, deletions we need to make.
Motion to adopt.
Second.
All right. Have a motion by Mr. Lee, a second by Ms. Stevens to accept the minutes as presented. All in favor? Any opposed? All right, minutes pass, and we will turn to Mr. Troy Bryant for our legal report. Good morning, Mr. Bryant.
Good morning, board members. The first complaint we have is complaint number 2022047521. An anonymous complainant alleged that an employee at respondent establishment was performing unlicensed activity by waiting on at-need families. Respondent replied stating that the employee does not wait on at-need families, but does assist licensed funeral directors who are waiting on at-need families. Respondent stated that during these meetings, a licensed funeral director is always present. Respondent added that specifically, this particular employee's duties are to help gather information from the family, while the licensed funeral director leads the meeting. Respondent further provided that the funeral director types, handles, and signs all forms, documents, and contracts. Based on the above, we would recommend closure.
Do we accept council's recommendation for closure?
Second.
Have a motion by Mr. Berry, a second by Mr. Lee to accept legal's recommendation of closure. Any further questions? All in favor? Any opposed? All right, moving on to number 2.
The next complaint number is complaint number 2022047321. This complaint was administratively opened following a routine review of respondent's website. On the staff page of respondent's website, it showed an individual's name and a photograph designating the individual as general manager. At the time, the individual was not a licensed funeral director. Respondent replied through counsel stating that confusion caused to the general public was not intentional, as the respondent listed the individual as general manager with the understanding that the individual had passed his licensing examination and that licensure was imminent. Respondent states that, in fact, the day they received the complaint, the individual received his Tennessee funeral director's license. Respondent adds that throughout the website, individuals who are listed as staff also specifically denote whether that individual is licensed. For example, the individual's counterpart, the location manager, is not only denoted as a location manager, but also as a licensed funeral director and embalmer. Respondent contends that since the individual listed as general manager did not have a similar designation, that chances that the general public would mistakenly believe the general manager was a licensed individual were further diminished. Respondent stated that in the future, they will refrain from publishing the name and photo of an unlicensed individual in conjunction with a managerial title. Based on the above, we would recommend a letter of warning.
Do we accept council's recommendation for letter of warning?
Second.
All right, I have a motion by Mr. Berry, a second by Ms. Stevens to accept legal's recommendation letter of warning. Any questions? All in favor? Any opposed? All right, move to number 3.
Next complaint is complaint number 2022049221. During the course of a routine inspection conducted on October 25th, 2022, the investigator determined that respondent establishment's pre-need seller's registration had expired on September 30th, 2022 and had not been renewed. During the inspection, a member of the respondent establishment informed the inspector that they had not written any pre-need funeral contracts during the time of the expired license. After viewing funeral files during the time of the expired license, the investigator found no evidence of any pre-need funeral contracts written. The website for respondent establishment displayed an advertisement indicating that the establishment offered pre-need funerals despite the expiration of the registration. Respondent renewed their registration on October 26, 2022, and respondent replied confirming that that registration had been renewed on October 26, 2022. Based on the above, we would recommend a $250 civil penalty authorized via consent order in a formal hearing if necessary.
Quick question, is this in line with what we've had in the past? I know there was a month delay there, but is the $250 penalty in line?
It is. I know on the kind of our round of complaints of when our investigators have gone out and seen kind of expirations for about this period of time, it's been consistent of $250 penalty for that period.
Move for approval.
Second.
All right, have a motion by Ms. Stevens, second by Mr. Berry to accept legal's recommendation, $250 civil penalty, authorizing consent order formal hearing if necessary. Any other questions? All in favor?
Aye.
Any opposed? Number 4.
The next complaint is complaint number 2022-050781. Complainant stated that they were hired by respondent on October 10th, 2022 as an office manager. Complainant stated that the employment started out fine because they, quote, did not have any deceased come in, end quote. Complainant alleged that in addition to office manager duties, respondent required her to also, quote, be in the room with her and help her put the bodies in the caskets and things that complainant was just uncomfortable with doing, end quote. Complainant contends that when she communicated that she was uncomfortable with that kind of work to respondent, quote, yelled at me and told me she hired me to help her, end quote. Complainant contends that following this interaction, respondent treated complainant, quote, very rudely and condescendingly, end quote. Respondent replied stating they had taken over as manager of the establishment in early June and that she was operating the establishment alone until complainant was hired on October 10th, 2022 as an office manager assistant. Respondent stated that for the entire month of October, the establishment received no calls. Respondent stated they used this time to attempt to train complainant in office management. However, respondent stated she soon learned that complainant struggled with many standard office management duties, including typing and spell checking documents. Respondent stated upon hiring complainant, and again after complainant started working at the establishment, they informed her that she would have to assist respondent with, quote, getting cots out of the van, casketing, possibly dressing, and helping me get the casket up the ramps from the prep room to the chapel, end quote. Respondent stated that at no time did complainant perform or was asked to perform license activity. As further evidence of this, respondent stated that due to the slow pace of the work, respondent had not even embalmed a body until the 9th of December, by which time complainant had already resigned. Respondent added regarding the allegation of yelling at complainant that on November 18, 2022, respondent had transported a body from a funeral home back to her establishment. Upon returning, respondent went to get the body while, as respondent describes it, complainant, quote, was just standing under the porch, end quote, failing to assist respondent. Respondent admits that she yelled at complainant to help because it was heavy and expressed that if complainant had issues with being around decedents, then complainant needed to find another job. Respondent says that following this interaction, they spoke with complainant, apologized for yelling, and asked that complainant take the weekend to decide if she wished to continue her employment there. Respondent stated that on November 28, 2022, the following Monday, they received complainant's verbal and written resignation. Based on the above, it appears that the majority of the complaint are work-related matters. The only tangible allegation appears to be complainant's allegation that respondent had her perform licensed activity without proper licensure. However, the activities described by both the complainant and respondent do not rise to the level of licensed activity, particularly when both parties admit that respondent only asked complainant to assist with pre-preparation work. Based on the above, we would recommend closure.
Questions for legal?
Recommend we approve council's recommendation for closure.
Second.
Motion by Mr. Berry, a second by Mr. Lee to accept legal's recommendation of closure. Any further questions, discussion? All in favor?
Aye.
Any opposed? All right, number 5.
The next complaint is complaint number 2022-044221. The department administratively opened a complaint after learning of a news story in which the respondent buried the incorrect decedent in a grave plot. This case was immediately sent for investigation. The investigator spoke first to the funeral director, who made arrangements with the family, who stated that she first made arrangements with them on October 12, 2022. The funeral director provided that the internment services were scheduled for October 18th, 2022, and that another individual had also been interred that day. The funeral director stated that approximately 30 minutes prior to the funeral service, she was notified by cemetery workers that the first individual, who had been buried earlier, had incorrectly been interred in the plot intended for the family she had been working with. The funeral director stated that the family was made aware of this mistake prior to the funeral service. The funeral director stated that her and the funeral home staff immediately made arrangements to correct the mistake, including contacting the family of the individual who had been incorrectly interred to have all necessary paperwork signed by the family to reinter him. The funeral director stated that the arrangements for reinterment were completed the same day, October 18th, 2022, that because of the late time, the family requested the decedent be reinterred on October 19th. The funeral director also stated that she contacted the family, who was informed during the service that arrangements were made to have the decedent interred on October 20th, 2022. The investigator spoke next to the manager of the funeral home, who was out of town when the interment mistake occurred on October 18th, 2022. The manager stated that the funeral director made him aware of the error and that following the conversation, he asked the cemetery manager to inform the family of the mistake. The manager returned the following day and met with the two sons of the decedent who had been informed of the mistake prior to the service and informed them that the funeral home had immediately begun working on obtaining all the documents required to disinter the decedent who had been incorrectly interred so that their father could be interred in the correct space. The manager communicated to the sons that their father would be interred at 3 o'clock that same day, October 19th, but that the sons declined and requested he be interred on October 20th, 2022. The manager stated that the interment of their father occurred on October 20th, 2022, and that he was present for the interment along with the family. The manager stated that neither family incurred any additional charges for the mistake made by the funeral home. The investigator spoke next to two brothers who were the sons of the decedent. They stated that at the time scheduled for the service, he and his siblings were called into an office by the cemetery manager, who informed them that someone else had been mistakenly buried in his father's grave. One of the brothers stated that they were informed of the mistake after several family members inquired the funeral home staff why there were no tent, chairs, or cemetery equipment at the father's grave. The brother stated that no staff member explained and only said they would check on the situation. One brother stated that the funeral staff informed him and the family that they would need to receive documentation in order to have the decedent disinterred from their father's grave, but that the burial could be done the next day, the 19th of October. The brother stated that due to family reasons, they requested the reinterment be scheduled for October 20th, 2022 instead. The brother stated that only 8 to 10 family members were able to attend the burial and that none of the friends in attendance for the service on the 18th were able to attend. The brother further stated that there was no committal service and that the family was there to basically only watch their father be buried. The brother further claimed that on the day of the burial, the manager was very, quote, unprofessional, uncaring, and extremely rude to him and his family. Based on the above, it appears that respondent, in failing to answer the family's repeated questions regarding the burial service and the manner of the manager's conduct on October 20th, 2022, respondent has committed unprofessional conduct. Based on the above, we would recommend a $1,500 civil penalty, plus half the cost of investigation, authorized via consent order and formal hearing if necessary. And just to make the board aware also, there is a companion cemetery complaint for this one as well.
Just curious, based on the previous history of this respondent, they've had unprofessional conduct before. I guess is $1,500 good here, or what can be our max here?
I do think we are limited to a $2,000 max, and that I think there are two specific instances of unprofessional conduct based on the information from the investigation that we have, which are that the family repeatedly asked, why is there no chairs, tents, anything going on regarding that? Can you explain something to me? And the alleged conduct of the manager. Since I think those two things, I will share that it got a little tricky of what falls under the cemetery heading versus what falls under the funeral. So I do think on this one, with just funeral specific, we're limited to a $2,000 civil penalty. I think that would be our max.
Well, based on the funeral establishment's unprofessional conduct, and then the cemetery complaint's going to handle the interment, disinterment, and
Correct.
thank
Yes.
you. Okay.
So cemetery and the funeral home under the same ownership?
They are.
No complaint against the funeral director itself, right?
That's correct. Just the establishment and the attached cemetery.
I have the same concern Mr. Harris has regarding the history, but I will make a motion to go with legal's recommendation.
Second.
All right, we have a motion by Ms. Stevens to accept legal's recommendation of $1,500 civil penalty plus half the cost of investigation. Second by Mr. Berry. Any further questions? All in favor?
Aye.
Any opposed? Number 6.
The next complaint is complaint number 2022-049231. During the course of a routine inspection conducted on November 3rd, 2022, the investigator discovered that the manager for the respondent establishment had a funeral director's license that had expired on June 30th, 2022, and was not reinstated until August 11th, 2022. Likewise, the manager also had an embalmer's license that had expired on June 30th, 2022, and had not been renewed at the time of the inspection. After examining the funeral files to the respondent establishment, the investigator found no evidence that the manager had served in the capacity of a licensed funeral director or licensed embalmer. Prior to the investigation on October 30th, 2022, the investigator received notification that a new manager had replaced the previous manager, the manager with the expired license from June 30th to August 11th. The current manager of the respondent establishment, new manager beginning October 30th, 2022, replied on behalf of respondent. Respondent stated they became aware of the first manager's licensure lapse the second week of August when that manager brought the new manager a letter indicating that the license had expired. Respondent stated that at the time they realized they had not notified the board of the manager's change in role as a community development representative. Upon receiving the letter, respondent contends that the original manager renewed his funeral director's license and arrangements were made to update the change in manager for the respondent establishment. The new manager states that their license was active during the time as acting manager from June 30th to August 11th, and that at all times a licensed funeral director was operating as manager of the establishment. Legal confirmed that respondent establishment had paid for a change of manager form submitted to the department on August 12th, 2022. Based on the above, although it does appear that respondent did have a licensed manager in place at the time in question, respondent still failed to notify the board of a change in manager within 10 days as required by applicable rules. Based on the above, we would recommend a $250 civil penalty to authorize via consent order and a formal hearing if necessary.
Do we accept council's recommendation?
Second.
Okay, we have a motion by Mr. Berry to accept legal's recommendation. Second by Mr. Lee. Any further questions? All in favor?
Aye.
Any opposed? Number 7.
The next complaint is complaint number 2022-049241. During the course of a routine inspection conducted on November 4th, 2022, the investigator determined that the pre-need seller's registration for the respondent establishment was not renewed at the time of the inspection. Specifically, respondent's pre-need seller's registration expired on September 30th, 2022. During the time of the invalid pre-need seller's registration, the respondent establishment wrote 11 pre-need funeral contracts with an invalid pre-need seller's registration. Respondent re-registered their pre-need seller's registration on November 11th, 2022. Based on the above, we would recommend a $500 civil penalty to authorize via consent order in a formal hearing if necessary.
I guess the recommended amount's kind of based upon the 11 contracts.
Correct, yes.
I'll make a motion to approve council's recommendation.
Second.
All right, have a motion by Mr. Berry, second by Ms. Stevens to accept legal's recommendation, $500 civil penalty. Any further questions? All in favor?
Aye.
Any opposed? Number 8.
Next is complaint numbers 2022-046151 and complaint number 2022-08691. Two complaints were opened against respondent alleging identical claims. Complainants allege that respondent, while an acting manager of a cemetery, had taken funds without the cemetery owner's knowledge by writing himself unauthorized checks and failing to deposit full amounts of sales items. Respondent replied, stating that in June of 2019, the owner and operator of the cemetery announced that they were retiring and asked Respondent to assist in the day-to-day activities as she would be moving out of town. Respondent stated it was apparent that they were going to be the primary caretaker of the cemetery after months of handling the cemetery. Respondent stated that in the fall of 2019, after meeting with the owner indicated that the cemetery could start paying Respondent for their work with the cemetery. Respondent stated that the owner added Respondent to the checking account and was instructed by the owner to pay everything out of that account. Respondent contends that in July of 2022, Respondent, quote, found out there had been a misunderstanding in the amount of compensation between myself and the owner of the cemetery, end quote. After discussing with the owner, Respondent stated they withdrew themselves from the daily activities of the cemetery and that Respondent repaid the funds to the owner that had been taken out of the cemetery fund. This case was sent for investigation. The investigator spoke first to the cemetery owner, who confirmed that she had spoken with Respondent about assisting her with the day-to-day operations of the cemetery as she was retiring and moving away. The owner indicated that Respondent agreed and that no financial arrangements were made between her and Respondent regarding compensation for Respondent's work. The owner stated they had some discussions with Respondent that financial compensation could be a possibility in the future, but no formal arrangements had ever been made. The owner added that Respondent's name was put on the bank account so that Respondent could pay bills for the cemetery. The owner stated that while reviewing the bank statements for the cemetery in July of 2022, she discovered that Respondent had been writing himself checks out of the cemetery checking account. The owner stated that the checks Respondent wrote to himself were not authorized and that Respondent did not have permission to write himself checks out of the cemetery account. The owner stated that after reviewing the bank statements, it appeared that Respondent had taken somewhere between $23,000 to $30,000 from the cemetery over roughly 3 years. The owner arranged a meeting with Respondent. During the meeting, the owner contends that Respondent apologized for taking the money and that he wanted to make restitution for the money he had taken. On August 9, 2022, the owner met Respondent and an additional witness in the parking lot of the funeral home Respondent was employed at. The owner received the files related to the cemetery that Respondent had in their possession, and that Respondent issued a check to the owner for $28,000 for the money that had been taken. The owner accepted this payment and took back control of the day-to-day operations of the cemetery. Next, the investigator spoke to the Respondent, who reiterated much of what they had said in their response. Respondent again maintained that he and the owner had some discussion that the cemetery could begin paying him for his work with the cemetery, but again stated that no formal agreements or a specific amount was ever discussed. Finally, the investigator attempted to contact both complainants. However, the identifying information that was provided, name, email address, etc., all seemed to be incorrect, as the homes the investigator attempted to visit were either not accessible or were not the homes of the complainants, and the email addresses provided came back as invalid email address. Based on the above, we would recommend a 2-year license suspension, and in that consent order will specify that Respondent will not work for or be associated with any funeral home during that 2-year period, 10 hours of continuing education, 5 of which must be in person, and 3 of those 10 must be in ethics, along with a $1,000 civil penalty, plus the cost of investigation, to be authorized via consent order and formal hearing if necessary.
So the owner that initially lost the money was not the complainant?
Correct. Based on, for all intents and purposes, the complainants we got were anonymous. They had information attached to them, but it appears that that information was not correct, and there was just no way for us to contact them. The owner said that because the restitution was made, they didn't proceed with anything, be that a complaint to this board or any criminal proceeding. That essentially it was in their view, the wrong had been righted, and they just wanted to get back to taking care of the cemetery the way it should be.
Well, the owner, I guess, never had any intentions of filing a complaint with the board?
That seems to be the case, yes.
It's a registered.
It is, yes.
I know we've had some others come up with this, and I'm thinking, did we not have a 2,000 civil penalty? Is there maybe a reason we're only doing 1,000 here?
I think specifically, given the on top of the cost of investigation, I think in the past, I looked back at a couple of these older ones just to make sure this recommendation wasn't just out of from left field. And I think there had been a $2,000 civil penalty one, but the cost of investigation were not applied. Given the costs, essentially balances out to about the same. But again, if the board would also prefer to bump that $1,000 penalty up, that's certainly within the board's purview.
But what is, I guess, legal and investigations feeling as to this being intentional or a honest mistake, he said, she said?
So, at absolute best, if we look in the light most favorable to the respondent, is that they seem to agree that there was maybe some vague conversation of, sure, we'll talk about financial compensation. The owner says, I said maybe we could do that in the future. And the respondent says, we talked about financial compensation. But both parties seem to agree that no formal arrangements were ever made. No specific amount was ever discussed. And I think it can be difficult to read in exactly what the respondent was thinking and what their intent was. But even in light most favorable to them, they still took, essentially paid themselves out of the cemetery account without any formal written authorization from the owner.
Thank you. That helps me on the
Sure.
decision.
So I'm a little confused on this one. Where is the funeral director in all this? I mean, this really doesn't fall into a funeral category, does it?
It gets lost a little bit, and I think that's on me for the way I drafted it. But this individual was helping their friend, the owner of the cemetery. But that individual, even though the bulk of this complaint is his involvement with the cemetery, he is a licensed funeral director. The respondent is.
I guess another question, I know in previous ones just similar to this, we've had a 1-year license suspension. Is there maybe a reasoning to the 2-year?
In this one, it's tricky, was in discussing this one and thinking what the best arrangement would be, it was tricky in that that's a large sum of money. But to the respondent's credit, they paid it back. But I guess you could always ask the question, if they never got caught, what would have happened? So the 2-year was essentially that these funds were kind of taken over the course of roughly 3 years, I think just shy of 3 years. Again, if that's something if the board would feel a little more comfortable with a 1 year, that's also totally fine. I also wasn't sure in the sense of I guess it would, to answer your question as shortly as possible, the balancing act of how long this activity had occurred versus what the appropriate period of time the punishment should be.
Thank you.
Another question for
Sure.
me. How do you police that this person will not be working or associated with any funeral home if they are not acting as a funeral or are not practicing it with a funeral license? They could be a courier. They could, be on removals. How do you police that?
It can, from my experience, certainly be difficult. It can definitely be a challenge, and that's I guess part of the aspect to weigh here is that it can be difficult. One thing that, and Mr. Gribble can probably speak to this a little better than I can, just on the practical level of how that can be accomplished. But what I have gathered, to some degree at least, is that the funeral directors in the state, even though there are many of them, is somewhat of a tight-knit community, and people know people. And I think it would be the kind of thing that if the respondent did have a license suspension and continued to conduct that activity, I think it would be very possible for it to get back to our department, and we could take further action from there.
I'm sorry. One quick question. When we go back to the summary of the complaint by writing himself unauthorized checks and also failing to deposit full amounts of sale items, do we know if that was going in his pocket as well, or is that something that an audit, I guess, would have to?
I do think it would most likely be something that would have to come through on the audit to know for sure. If I hesitate to say this because it's essentially conjecture, but I guess my impression was that in between was where the self-writing checks were coming from, but I don't know that for certain, and I do think an audit following that cemetery will reveal them.
So my question is, that I don't understand how we can, certainly we have the authority to suspend the license, and that should prevent the individual from practicing as a funeral director, but I don't see how we have the authority to be able to stop him from working at a funeral home at all. It seems like that's overreaching from the standpoint of he's not working as a licensed funeral director anymore at that time. How can you prevent him from doing anything at a funeral home?
And I think most likely that's a mistake on my part in the drafting. I guess I should have been more clear, and that's something that if the board approves this, I will make sure to be very explicit in the consent order. That as far as the association with the funeral home would be the license activity, essentially. That whether one be essentially, I guess, to the point of being hired as a funeral director would not be allowed, or essentially, okay, we'll bring you on and you can do under the table the work of a licensed funeral director. That's the point I was attempting to convey in that one, though my mistake on drafting and not making that clear.
Other board members, I'm struggling with the 2
Yeah,
years
I am too.
suspension.
Well, and I'm struggling because they did admit to it. They paid it back, and that's messing with the major livelihood of an individual. I agree they've confessed they're wrong, but I'm with you. I'm struggling.
Throw it out there. I'll make a motion for a 6-month suspension. Everything else, council's recommended.
Okay, we have a motion by Mr. Berry to change the recommendation from legal to a 6-month suspension, specifying the respondent will not work for or be associated with any funeral home during this time. 10 hours of continuing education. 5 must be in person. 3 of the 10 must be in ethics. $1,000 civil penalty plus the cost of investigation with the authorized consent order for more hearing if necessary.
One question before a second. Now, as far as him not working or associated with any funeral home, that's going to be for licensed activity, right?
I understand.
Okay, then I agree with you. I'll second the motion by Mr. Berry.
Okay. We have a second by Mr. Lee. Any further questions on this case? If not, all in favor?
Aye.
Any opposed?
Aye.
All right, let the record confirm that Ms. Stevens voted against. All right, number 9.
Next complaint number is complaint 2022-049081. Complainant, daughter of the deceased, alleged that respondent had cremated their father without permission. Complainant stated that their father passed away on November 18th, 2022, and was transported to respondent establishment, where he was supposed to be held until a meeting on November 19th, 2022, to make the determination as to whether the family would decide to cremate or bury. Complainant contends that they did not sign any documents or pay for services. However, complainant claims that her brother was called by respondent requesting approval for an emergency cremation due to a bedbug infestation. Complainant contends that respondent should not have been allowed to do a cremation without there being any documentation signed and approved by the person with authority to make the decision, who complainant implied should have been them. Respondent replied stating that the decedent passed away on November 18th, 2022, and that the respondent establishment contacted the son and the father of the decedent regarding arrangements. Respondent stated that during this conversation, the father of the decedent requested a cremation for the decedent. Respondent also attached a recording of this conversation and legal confirmed that the person respondent spoke to did request a cremation. The family members informed respondent which funeral home the decedent was at and requested that they transport him to the respondent establishment. Upon contacting the funeral home, respondent was informed that the decedent had a bed bug issue as they saw several crawling on him and the sheets. During transport, they observed a significant amount of bed bugs on the decedent. After transporting decedent, respondent requested an emergency cremation permit from the medical examiner's office, but stated that they would need an authorization from the next of kin. Respondent reached out to the son of the decedent, who they had spoken to earlier. Respondent stated they received a text message from the son granting permission. Respondent attached the text message to their response and also received verbal authorization at 4:57 p.m. on November 18th, which was noted on the cremation authorization form, which was also included as part of their response. Following this, the medical examiner issued the permit for the emergency cremation. Respondent stated that on November 19th, 2022, the son and the father of the decedent arrived at respondent establishment, paid in full, and at no point mentioned anything regarding a burial. The son of the decedent signed the contract for the cremation, which respondent included with their response. Finally, respondent stated that on November 22nd, 2022, 4 days after the decedent passed away, respondent received a call from complainant, the first time complainant had contacted respondent regarding the decedent. Likewise, respondent stated the son and the father of the decedent never mentioned any other children of the decedent. This was also the first time respondent were made aware of the decedent's other children. During this call, complainant informed respondent that she had preferred a burial and that she was upset regarding the cremation. Respondent stated that this was the first time any member of the decedent's family had ever mentioned a burial. Complainant filed a rebuttal stating that the son should not have been regarded as the next of kin because she, complainant, was the oldest sibling. Based on the above, the respondent was able to produce an audio recording of the son giving verbal permission for authorization, an authorization form to show the verbal permission, a text message from the son giving permission for the emergency cremation, and a signed contract from the son agreeing to the contract for cremation, which was signed after the cremation had occurred. However, during the audio recording, and apparently at no time during the process, did respondent inquire to the son or father of the decedent whether there were additional siblings, a spouse, or someone appointed with power of attorney. From the search of the decedent's obituary, there were 4 children in total. So based on the above, we would recommend a $250 civil penalty be authorized via consent order and formal hearing if necessary.
Any questions for legal?
These audio recordings, was the actual paperwork, authorization forms and things like that inspected?
It was. So they attached, in total, what we had was an audio recording with that conversation, a cremation authorization form that they got verbal permission for, a text message from the son they had spoken to granting permission for the cremation, and the son had come in person and signed a contract, which on that contract were the price list and services provided for direct cremation.
May have mentioned this, but did the person in the recording, did the funeral director ask the family if there were other family members?
They did not. And one thing I will say, this was, I think, a close one in the sense of looking at the law. I agree that the respondent does not have to go looking for family members that they don't know exist. If hypothetically the son had said on that call, "Oh, I'm the only son and I'm the only child," and had lied, then it's reasonable for the respondents to believe them in that situation. But I think where, from legal's perspective, they fell short of their duty of professional conduct is that at the very least you have to inquire. And true, you don't have to go searching in the ether for siblings or spouses or power of attorneys that may or may not exist, but you do have to ask.
I mean, that's on the family authorization form. You know, you start with spouse and then you kind of exclude family members to get where you're going. And I would almost say 9% of the time, the funeral home probably wrote the obituary they put in the paper with the 4 other.
That's what I was getting ready to say. You said there was obituary. Did the funeral home do that obituary?
I'm not certain. I know that obituary was not provided in the information, but I found it online, essentially.
You say online, was it on their website?
It was.
Have been written after the cremation.
You're saying none of the paperwork was signed until after the cremation, right?
The contract, I guess all of it was done over the phone with exception to that contract where the son did come in and sign it and initial it himself. That documentation was the only one that was done after the cremation occurred. They had everything else before, but they had not gotten the son in person to do any of that. It was all online and verbal.
You have no documentation that states when they received the obituary that they placed on their website, correct?
Correct.
Something in there about, not officially asking who the next.
I've got a lack of attention on this.
I don't know that we. Can you mix basically a penalty plus a letter of warning addressing that this board feels like in situations such as these that there should be the question asked?
I don't know that there would be. I think it could be, I guess, probably mincing words, but I think with the letter of warning being a specific disciplinary action and the civil penalty kind of covering that, I'd be happy to include essentially a letter of instruction saying, the due diligence of inquiring about other potential next of kin. I'd be happy to do that.
And you feel like 250 is sufficient here with everything that's gone on in this case?
Again, I think from the legal side, I see where it's a close call, but as I've mentioned several times before, I know you all kind of fill in for my lack of knowledge on the actual practical business side of all of this. So if you feel that due diligence was so severely lacking that it should be bumped up, then that is certainly the board's purview.
I'm going to make a motion. We accept council's recommendation of a $250 civil penalty.
All right, I have a motion by Mr. Lee to accept legal's recommendation of the $250 civil penalty.
Is it okay for him to add to that the instructions?
Oh, I'm sorry. Thank you. And to add the letter of instruction as well.
I'll second.
Okay. So we have a motion by Mr. Lee to amend to say a $250 civil penalty with a letter of instruction, seconded by Mr. Berry. Any further questions? All in favor?
Aye.
Any opposed?
Aye.
All right, let the record show Ms. Stevens voted no. Number 10.
Complaint number is complaint number 2022-051311. Complainant, son of the deceased, alleged unprofessional conduct against respondent establishment. Specifically, complainant provided that their father had passed away on March 7th, 2022, and that they had entered an agreement with respondent 2 days later and signed a cremation authorization form. Complainant contends that since they were unable to have the necessary funds for a direct cremation, respondent offered to take half to get the cremation process started. Complainant was unable to procure half until April 11th, 2022. During this time, the decedent had remained in the custody of respondent establishment. Complainant stated that they paid the remainder of the balance on April 21st, 2022, and that they were given the cremains along with all the necessary paperwork. Complainant stated that after examining the provided paperwork, they noticed that their father had been cremated on March 19th, 2022. Complainant also alleged he had yet to receive the death certificate for the decedent. Respondent replied, confirming the financial details as complainant had described them. Respondent contends that after several unsuccessful attempts to contact complainant by phone, due to the fact that the decedent was in an advanced state of decomposition when received, the decedent was cremated on March 19th, 2022. Respondent next contends that complainant stated he would be in on April 5th, 2022 to pay for the cremation in full. However, on April 5th, The complainant did not contact respondent establishment, and respondent was again unsuccessful in contacting complainant. Finally, respondent agreed that complainant paid for the cremation in full on April 21st, 2022, and confirmed that the remains were released to the complainant the same day. Respondent provided that the cause of death was updated in viscerum by the medical examiner on June 15th, 2022. However, respondent contends that they made several unsuccessful attempts to reach complainant by phone to inform him of the finalized death certificate that was ready for complainant to pick up, and adds that at no point has complainant ever contacted anyone at the respondent establishment regarding the status of the certificate. Based on the above, it appears that respondent did have the cremated remains of complainant's father as early as mid-March. Respondent did not provide the cremated remains until April 21st, 2022, when they had received full payment from complainant. Further, legal spoke with respondent and confirmed that as of January 26, 2023, they had not provided the death certificate to the complainant. Legal took steps to ensure that the death certificate would be received by the complainant shortly after the conversation with respondent. Based on the above, we'd recommend a $500 civil penalty authorized via consent order in a formal hearing if necessary.
So in a nutshell, he had the proper paperwork to do the cremation when he did. He just didn't have all the money.
Correct.
But then he went ahead and cremated, which was fine, but then held the remains till final payment.
Correct.
It also had not notified the family that he was moving forward with cremation.
Correct.
Do I understand he did not file the death certificate through Verizon, let it sit there for 3 months?
From what I understood, it had been filed, that the medical examiner updated it in June of last year.
I noticed you also said something about as of January 26th. Do we know, has the family now received this?
So, from my best efforts, I hope so, we'll put it that way, I attempted to contact respondent to ask if they had received it and do whatever I could to set up a way to get that death certificate to them at the very least. It went immediately to voicemail and would not allow me to leave a message. So I do understand respondents' difficulties in getting in touch with them. I asked them, if that was their protocol, that do you only give them the certified copy in person? Do they have to come in? They said it's their preference, but that they did have an address for him. And I requested that death certificate be sent to that address they had on file. At one point, I think during this process, the respondent did have an attorney, and I contacted that attorney to see if we could have that sent there, but unfortunately, he was no longer representing that individual. So,
I have a quick question. So the cremation authorization was signed at the original meeting,
correct.
and correct me if I'm wrong, Mr. Gripple, but on most cremation authorization forms, cremation can take place at the will of the funeral home for their scheduling.
Typically, that's true on most of them.
So that funeral home or funeral director, funeral establishment, cremating and not letting the family know that was the date that they were cremating is not it's not a violation.
I think that would come into, and again, I would defer in the sense of you all know the business better than I do, but that would potentially fall under an unprofessional conduct, whether that is something that's typical or not. But I think what I've been apprised of is kind of the primary violation here of unprofessional conduct is that essentially having the cremated remains as early as mid-March and hanging on to them for about a month until full payment was received. And I also understand from the funeral director's perspective, those services aren't free, and I certainly understand that. So The violation is kind of the balancing act of this situation that the funeral director was in, and whether how they went about the situation is cumulatively unprofessional conduct.
You don't know family history. They may have 2 or 3 other families that still owe them money.
Correct. That's certainly possible.
My opinion, I mean, that's certainly a best practice and good customer service to do the notification, but I don't see that there's been any kind of violation with that. So I'd make a motion, just a letter of warning.
No penalty.
All right, we have a motion by Mr. Berry to change the recommendation to a letter of warning only.
Second.
Second by Mr. Lee. Any further questions? All in favor?
Aye.
Any opposed? Aye.
Just want to make sure I get on record who said.
I opposed.
Okay, thank
Yeah.
you.
Thank you. All right, number 11.
And the final one is a represent, is complaint number 2021-048911. The way this one was presented back, I believe, in September of 2021. This is a consumer complaint alleging unprofessional conduct. Specifically, the consumer alleges the following. 1. The respondent failed to provide price information on the telephone as required by the funeral rule. 2. The respondent failed to inform a son of the deceased as to how to obtain a certificate of death. 3. The respondent failed to treat a member of the public in a respectful manner. The respondent's attorney responded to the complaint and indicated that they are not obligated to provide copies of death certificates to persons other than the person whom the respondent has a contractual relationship with. The respondent indicates that they were not asked for a price list during their conversations. The consumer provided a rebuttal indicating that the respondent refused to provide a price list. The consumer further stated that the death certificate has false information on it and the individual who contracted with the respondent lied about their relationship with the deceased. And it was decided a $500 civil penalty. So the new summary for this information, respondent provided additional information related to this complaint. First, the party that respondent contracted with was the wife of the decedent. Counsel for respondent stated that complainant had alleged throughout that the wife of the decedent was not the lawful wife of the decedent. This is confirmed in complainant's complaint, where complainant alleges that the wife was the, quote, bigamous partner, end quote, of the decedent. Due to the tension of the situation, respondent stated that the wife asked that the respondent not provide the complainant with a copy of the death certificate or any other information related to the decedent's arrangements. Respondent stated that complainant was not asking for a price list, but asking for the price to purchase a death certificate. Due to the specific instructions of the wife, respondent denied complainant's request to provide information regarding a death certificate, but states that they did provide the complainant information about how to obtain the death certificate from the Department of Health. To further prove this, respondent attached a letter that they had sent to complainant containing the contact information of the Office of Vital Records and how to procure a death certificate. Respondent also attached a letter from the wife who confirmed that she was the designated next of kin and the only person who made the funeral arrangements and paid for the services. In the letter, the wife confirmed that she requested that respondent not release any information to complainant, including the death certificate. Based on the above, it appears that the crux of the complaint is a family dispute. The wife of the decedent, who respondent had directly contracted with, specifically requested that respondent not provide a death certificate to the complainant. Respondent followed this request and provided an alternate method for that complainant could obtain a death certificate. So based on that new information, we would recommend closure.
Move for approval at legal's recommendation.
Second.
All right, we have a motion by Ms. Stevens, a second by Mr. Berry to accept legal's recommendation of closure. Any questions? If not, all in favor?
Aye.
Any opposed? All right. Thank you, Mr. Bryant. Any further comments from you, sir?
I think just a very minor update to the board. I know if you all recall our rulemaking hearing last year in May. Just wanted to let everyone know that those rules became effective on February 3rd. Got through the litany of steps and hoops to jump through, so those are active and everything went through smoothly.
Perfect.
President,
Yes, sir.
not exactly sure how to do this, but I would like to go back to number 8 again. And as we've been proceeding, I just keep on thinking about this matter. I know that we've already voted on it, so I don't know what the procedure would be if we wanted to amend the motion.
I think the proper procedure would be a motion to reopen the legal report and that complaint specifically, and then if there was a further discussion or anything like that can occur.
So moved.
Second.
All right, so we have a motion by Mr. Berry, a second by Ms. Stevens to reopen complaint number 8, and we will open that for discussion.
In continuing to think about this and the seriousness of a suspension, it seems to me that maybe we should ask the investigator to go back to the owner of the cemetery and get specifically from him in writing. I think the owner of that cemetery needs to understand the seriousness of this allegation and that there's, possible suspension on the line, because to me there's this unanswered question about what this agreement was between them. And if this went over a 3-year period and you're talking about $9,000 a year that this person was taking to pay for service, something's not right there. So I think we ought to at least ask the owner of the cemetery a little bit more detail about that, and that he understands that the recommendation is suspension of license. Then after hearing back from you, whether that is at the next meeting, then we make a decision on how to proceed with this.
I agree totally. The reason I went with you on the 6 months because it was a lot less than 2 years, but the owner never complained. And there's more to it. And then, of course, the 2 complainants were frivolous. I just have a thank you.
So let me ask this question, because I agree with that. I think you'd brought this up as well. There's not been a cemetery audit done either for this period, correct?
For this period, to my knowledge, there's not been.
So is there a way that we could also, I agree with what you're going after here, is also table till we see what comes from that audit, so we have both views to look at? Is that possible or not? Because that's on yeah, it's on. Never mind. I answered my own question. Because it'd be on the cemetery audit.
We can't really make
We can't make a decision on
that's
that.
up to
Yeah.
burial services.
And just for clarity, so when you're referring to the agreement, it's kind of this agreement between the owner and the respondent that the respondent would take care of the day-to-day of the cemetery, essentially. That's what the agreement you're wanting more information on. Okay.
Yeah, there's just not, it'd be a lot different if we had both parties here and we were able to ask questions, but this is not a hearing. So I think it's a little bit of a reach for us to come to a good conclusion when we can't ask all the questions that I think need to be asked.
Any other questions about legal number 8?
For some reason, if we can't get clarifying information the next time that this is heard, then we'll make a decision at that point as to what to do.
I'll add just a couple of things just for more context. This may or may not change anything at all, but what I understood from, because that question wasn't asked specifically of what were the specifics of this agreement. What appeared to be the case is that these 2 individuals, the owner and the respondent, were friends, and that kind of as a almost a favor of, hey, I'm moving off, I'm retiring, will you take care of things? That's kind of the extent, and I agree there's a big gap there, so happy to fill that. And kind of in the timeline of how this occurred is that the respondent went to the bank to try and cash an additional check, and it was denied. And so the way it was all discovered essentially was when that owner was looking through the records in July 2022, saying, okay, we're missing a lot of money here, and I'm not sure why. They essentially froze the ability on the account, money to be moved around the account. And so that's how it was discovered, is the individual was going to essentially write himself another check out of the account, and the account was frozen.
So, I mean, it's definitely, theft is very serious, and I mean, and that's certainly gets into the ethics of being a funeral director, but I still just feel like there's not enough information there for us for me to recommend that suspension at this point. I'd like to try to get more information and make sure that the owner of the cemetery knows how serious this board looks at that, make sure what that response is going to be.
You saying that they're friends, do you feel like the owner would give us a true report of his feelings and what's happened?
I do, because I think the owner was very straightforward in their statement that they made of kind of, again, they seem trustworthy in what they provided. Their account of the situation appeared to be an unbiased account of what had occurred and kind of stuck to the facts of the matter.
Yeah,
Motion.
I made that in the form of a motion. It's convoluted. I don't know if would table be the right?
Further investigation.
But table it or to...
Yeah, I think that would table for discussion.
But you have to have a motion then to bring it back. Is there a better way to do that? Or
I think can probably just make a motion to withdraw the previous one, which would be a separate motion, and then
made that. Okay, so I make that motion to withdraw the previous.
All right, so Mr. Berry's made a motion to withdraw legal number 8. And then, do we need a second to do the withdrawal before he makes the new motion?
Yes.
Okay. So he's got the motion on the floor. Do we have a second?
Second.
All right, second by Mrs. Haynes. Any other questions on that? All in favor for the withdrawal?
Aye.
Any opposed? All right.
Then I would make a motion that for further investigation, that the owner of the cemetery be contacted to see if we can get more information. And I think specifically, the owner needs to realize the seriousness of the recommendation of what the attorney for the board is recommending, and make sure that the owner of the cemetery knows that and get information from him, because he may change his tune a little bit, is what I'm concerned about. So make that in form of the motion. Sorry, it's convoluted.
So Mr. Berry has a new motion to have more investigation done here with a response from the owner. Any questions or a second?
Could I add that be brought back at our next meeting?
Yes, I do know that our usually it kind of comes down to the investigator schedule, but we can let our investigator know, let's prioritize this one, let's get an additional statement from the owner, and barring any unforeseen circumstances, I think it should be able to.
I'll second Mr. Berry's request.
Okay. So Ms. Stevens has seconded Mr. Berry's motion with the addition that we have this brought back by the next meeting. Any further question?
Let me make the board aware. The investigator schedules investigations for pretty far out, and sometimes the respondents don't always follow the timelines when they ask them to meet with them. And could we have some leniency that the investigator do it, make it a
Sure.
priority, and bring it back as soon as
I just don't want us to
possible?
forget it.
Pardon?
I just don't want us to forget it.
Well, we won't forget it, but I have some concern if we
Sure.
can. I mean, sometimes there's other investigations that come up that might even take priority over that.
Sure.
You know, if it's something that has to be where an investigator has to be on the scene to do something a certain date, and we certainly want to do what the board wants, but I'm just asking for a little leniency as far as the
Absolutely.
investigator's schedule.
All right.
And we'll make every effort to have it done and back where you can have it back to legal in time for the next meeting.
Any further questions? All right. All in favor in the motion that is before us?
Aye.
Any opposed? All right. Any further discussion on legal or anything from Mr. Bryant?
Eagle has nothing else at this time.
Okay. All right. Thank you, sir. We will now open the floor for Mr. Gribble's Executive Director's report, please.
Thank you, Mr. President. Good morning, board members. In the information you received regarding a legislative update, the attorney and I had a discussion, and we thought that these bills were the ones that were most pertinent to this board that we've listed. However, there are many other bills that could have some effect to funeral directors or cemeteries, and we didn't try to be exhaustive in listing those. But Ms. Bohannon sent yesterday to you these bills and the actual bill as it was introduced, and keep in mind that those bills can be amended as it works through the legislative process. But the first bill is House Bill 0939, Senate Bill 0934, reduces from 180 days to 90 days the amount of time in which an operator of a crematory facility must wait from the date of cremation before interring, entombing, or urning unclaimed cremated human remains. House Bill 0074, Senate Bill 0255, updates the terms General Education Development Credential, High School Equivalency Test, and variations of the terms to High School Equivalency Credential. And this affects several regulatory boards, not just the Board of Funeral Directors and Embalmers. House Bill 1173, Senate Bill 1197, requires an insurer to provide the names of the beneficiaries of the decedent's life insurance policy, the benefit amount under the policy, and other information requested by a funeral director or funeral establishment that contacts the insurer on behalf of the decedent's family. House Bill 0242, Senate Bill 0307, requires the individual that signs a death certificate of a decedent or an agent of that individual to ask whether the family or other appropriate person wants to make an anatomical gift of the decedent's body or part, prohibits a procurement organization from contacting the family or other appropriate person if the family or other appropriate person refuse to make an anatomical gift of the decedent's body or part. And then House Bill 1094, Senate Bill 1114, requires a procurement organization or such organization's designee that contacts an individual following the death of the decedent for purposes of allowing the individual to make an anatomical gift to explain to the individual that the decedent can designate the decedent's whole body or part, the process of making an anatomical gift, and the condition of the decedent's body will be in after the completion of the process, and that the decedent's body may be in a condition that necessitates cremation of the remains. And then House Bill 0023, Senate Bill 0027, requires governing bodies to make agendas of meetings and supplemental meeting documents available to the public at least 48 hours prior to the meeting. And then the website's listed there for you to search other bills that you might wish to search, including more information regarding these. Financial information. I just wanted to make the board aware of two things that will affect the expenses of this board for the fiscal year July 1, 2022 through June 30th, 2023. DOHR, which is the Department of Human Resources, what we call Big HR, did a job classification study and realignment of the salaries, mostly to frontline employees, in November of last year. And then in January of this year, employees were receive bonuses based on pay for performance. And as I said in November, that was mostly frontline employees, but that affects, a person in the board office, that affects centralized complaints, that affects customer service center. That could, of course, we have our own investigator. Most of the investigations are done by this board, but then occasionally there's some done by the investigative unit of regulatory boards. So those are much needed things to be done, but it is going to create expenses to the board, and salaries will be in a larger amount at the end of this fiscal year. So in transparency, we wanted to make you aware of that so that there'd be no surprises when that happens. Licensee reports. A report of licenses administratively approved by the executive director pursuant to board authority for the period of December 10, 2022 through February 10, 2023. And you have those listed there before you. Closed establishment report. 2 establishments were reported closing since the last board meeting. One Click Cremation and Funeral Care, 1332 Rosa L. Parks Boulevard in Nashville, and Tennessee Cremation and Mortuary Service, 2558 Highway 41 South in Greenbrier. Disciplinary action reports. A report of consent orders that have been administratively accepted or approved by the executive director pursuant to board authority, and as reported on the November 2022 and December 2022 regulatory board disciplinary action reports. And you have those listed there as well. Complaint report is a report of complaints as of February 9, 2023, 11 for a funeral director and or embalmer, and 14 for establishments, for a total of 25. And I'll be glad to answer any questions about any of those items that you have. That concludes my report, but I'll be glad to answer questions.
Mr. Gribble, so like you do the complaint report here, keeping up with the numbers. Does the department ever do a report that indicates, like, for the year, how many establishment licenses were granted, how many funeral director, how many embalmer licenses? Do you do any kind of report like that?
Don't do it in a cumulative report. Of course, we report that each month in the and as I report to you, like on the licensee report.
Would it be possible to do a cumulative report?
We could.
I think that would just be an interesting thing that
we could, at the end of a fiscal year, we could do a,
like in January or February of the next year, you report on the previous years.
It would probably, if it's okay, it'd probably be good to run to the fiscal year, since most everything the state government does is in July 1 through June 30th.
I think that would be an interesting stat for the board to be aware of, to see.
Probably pull those numbers pretty quickly for that.
Okay, that would be possible. I think it'd be.
I can tell you that the numbers never increase substantially, nor decrease substantially, because you have people coming in, and then you have people that let their license expire, or you have people, unfortunately, that pass away. So we stay somewhere close to 3,000 funeral directors and embalmers, and it's been pretty much that way for the whole time I've been here. It will ebb and flow a little bit, but there's about 1,900 funeral directors and about 1,100 embalmers in the state, and like I say, it kind of evens out as far as the number that come on board as new licensees, and then the number that either let their license expire or.
Roughly how many establishments are there in the state?
102. Roughly 600. 83 cream. Out of the 602, about 83 of them are crematory.
I just think it'd be really nice to be able to see
that number's
a report.
Up substantially, obviously,
Yeah.
than what it was several years ago.
I'll make a motion to accept the executive report.
Second.
I have a motion by Mr. Berry to accept Mr. Gribble's executive director's report. Second by Mr. Lee. Any further questions for Mr. Gribble? All in favor?
Aye.
Any opposed? All right. Thank you, Mr. Gribble. Do we have any individuals to appear today? All right. No individuals for application for licensure, but we do have an establishment, the cremation company. So those that are here for the cremation company, if you'll come forward, please. Morning. We'll give you time to introduce yourself and tell us a little bit about yourself.
So good morning, and thank you, board members. My name is Chuck Crawford. With me is Ray Visotsky. He is going to be the president and funeral director at the cremation company. 25 years ago, I appeared before the board to ask for an establishment license for a crematory. That's 1998. 20 years before that, I was at John A. Gupton College when the board shut down Woodlawn's crematory, the only one in Nashville. And for several years, there wasn't even a crematory in this town. The nearest one was in Louis. Now I'm in front of you asking for an establishment license for a business that will primarily, almost exclusively, make cremation arrangements. Primarily online. And I highlight these instances because times are changing. When I started in this business, it was much different than it is now. So what we're trying to do, I know two of you are from the national, trying to compete, have to have some ability with people. Cremation. I'm operating setup. What we're looking to do is not stray far to the mic.
Slide up there a little
Right
bit.
up
There
on
you
it.
go.
How about if I lean on here? The capacity crowd, I don't want to leave Mr. Batson out of anything. I'm sure he's recording this. So what we're trying to do, and what we've done from the very beginning, is we own our own buildings, we own our own machinery, we own our own personnel and vehicles. Same format we're going to continue with. We're going to initially put ourselves out of our building that we're in now. And we put a letter of intent on a 5,200 square foot building in Nashville, and we're going to install 2 crematories, refrigerator, autopsy room, as well as an embalming room, offices, and a call center. So this is going to be an expansion of our current business, operated much in the same way we've operated since we opened up in 1985. I'll leave it for questions.
All right. Mr. Vitsky, did I say it right? Vitskotsky. If you'll come and introduce yourself as well, please, sir.
And my name is Ray Visotsky. I have been a licensed funeral director since 1983, working in several states through my career. Former owner of several funeral homes and cemeteries, which was a former member of the South Carolina State Cemetery Board. Mr. Crawford and I have been acquainted for many years, and back in March of 2017, we started talking about this idea, this concept. And so again, I'm excited to come here and to put our combined experiences together to try to create a new business.
Sure. We will open the floor for questions for either of these gentlemen.
Wasn't quite sure. So have you actually received your license for Tennessee?
Yes, sir.
Okay.
Reciprocity last month.
I do understand you are the manager and not Heidi Crawford, because we had an update there, correct?
So that is correct, because at the time we made application, I had not received my license yet, but since I did, we've made that change.
So could you elaborate a little bit regarding the processes for online cremation?
It's not uncommon these days that websites have the ability where people could go online, provide vital statistics information, and also DocuSign, if you would, cremation authorization forms, which would need to be, well, everything reviewed by the funeral director, but as a for them, they're able to do that. So again, we have a website that's under construction now that's not live yet because we're not licensed yet. It's pretty much almost ready to go. People can do that. If people are not able to utilize the website, again, we can email forms or we could have them come into our office to make those arrangements. And again, we know that oftentimes people who make these arrangements are doing so from distances away, and as a convenience, again, we're able to provide that service without making them come in.
I have a couple more questions, okay? Made some notes here. So there are 3 companies, and if I'm not stating this correctly, interrupt me. So there's Mortuary Associates, the cremation company, and Crawford Funeral Home. Is that correct?
The Mortuary Associates is a C Corp. That's what I started in 1985. The DBA, which is Crawford Funeral Home, the other DBA is the cremation company. At one point, we had 2 other locations in the Nashville area, but these are just extensions of a C Corp. So they're all operated under the same ownership.
On your casket price list, it does not show a charge for embalming, in which you put on there that is a service that you all don't offer. But let's say someone goes online and they want to see their loved one and they want them embalmed. What is the process then?
Pass that off to the other company,
To the
funeral home.
company.
And that was a big discussion we had. It's interesting, but in all these years, as we expanded and contracted the business, we found that in the building that we're in now, which is what I bought in 1995, there are quite a few people on the funeral side that never see our building. They never come into it. And even when it came to having bodies viewed that were unembalmed, we were on the forefront of that back in the late 90s, where people had wanted to come in and just have a private viewing prior to a burial, but not have any embalming. So we were able to do that, and we found that if we could reduce our obligations to the family as far as the exposure that they had to us and make ourselves a minimum of what they had to deal with, they appreciated it. You know, all of you are funeral directors. You might be, are you the consumer guy? Okay. I won't put you in our team then, but I understand. When a death occurs, as you all know, the family gets incredibly busy. It's answering the phone, if nothing else. So we try to make sure that we can minimize what they have to do with us and that we can handle our end of it. And we've seen this, manifest itself in the cremation world, where people want to try to simplify what the processes are. And I think we can do that with them through the cremation company. But this is a big discussion we had going on, trying to define for ourselves, what are we doing? You know, what is this cremation company? And it was people that seek this out. Some of it's economic concerns, right? Cremation has become a commodity. It's now not so much how it's done, but how much it costs. So we wanted to become more of a specialist in that arena. But then when people do require other services, we're capable, because we own and operate a funeral home, to supply those things for them.
One other thing, and I'm in the Nashville area, and I've not ever seen your location, but based on these pictures that were sent, and it could be they're updated or whatever, 700 Craighead Street, Suite 110, on page 1 of 4, the building's brown. And then when you go on back here, it's 700 Craighead Street, and the building is white.
Ray's tenacious. He's from New Jersey.
Mm-hmm.
And he told the guy, if you don't paint the building, we're not coming in. No, it's just an older picture.
Okay.
It's white now. Actually looks good.
Please understand me asking, because
Oh, yeah.
we it's presented to us, and we want to make sure that we are approving the right building.
So, question going kind of a follow up to Pam. So if a family does want some viewing, minimal prep, embalming, you would totally switch that over to Crawford Funeral Home,
Right.
and
We
then
would
those
make
charges would be on that GPL. And
We would make a suggestion that number one, we couldn't provide those services, and number two, we would suggest that they would use Crawford. Certainly be their choice. It's no different from anything else. We're just not in that.
I think that's unique from what we've been seeing over the past few years, as far as services similar to yours. As far as typically there are charges on that company's GPL to cover things that are very common with cremation.
They
So-
are, Mr. Barry, and I think that if you want to take a strong look at this, one of the things that I take issue with is that we have people out there working out of a single office that are offering funerals. How is that possible? I mean, how is the public supposed to discern between somebody working out of a single office and what they consider to be a funeral home? And of course, when it comes to the facilities, if you want to talk about 10,000 suite versus 5,000 square feet or whatever, that's not really important. But what we're doing with this is we don't want to mislead anybody into believing that this is something other than what it is. It's an arrangement process for cremation. I think this is a large enough portion of the market that wants a direct difference being background of that. I'm not farming this out to trade services, and I think that's a big distinction between what we're doing and what's going on in the rest of in the state.
I'm just thinking from the consumer standpoint, if that is any kind of burden on them when you're having to switch to, if they want to have a viewing, that you're needing to switch to another funeral home, a GPL, another contract. Seems like that's burdensome to the consumer.
It could be the same thing if all we'd like you to cremate other, have your own machine.
Oh, but everything's still under the control of that GPL and that contract, even if you're using a third party crematory.
Family preferred that they find a crematory. Have to change it.
I just personally got some concerns wrapping my head around that you don't offer. You are offering it, but in order to offer it, it's going to have to transition over to another.
Fourth Street. Symbols, because I think it's good consumer.
So I've got a question as far as your GPL. Looking over those numbers, there's some discrepancy from what I've added up here. Is the direct cremation total fee that you're presenting the $695? Is that correct?
Yes, sir, that's correct.
Okay. So when I add up your line items to get there, I think I'm right. They add up to $750. So I'm just curious how we're getting to the $695 versus the $750. So there's some discrepancy that I'm seeing on the GPL. Can you maybe explain to that?
My first response to explain to that, it may be a function of this may be one of our drafts, because over the weekend while I was away, Mr. Gribble asked us to resend this because apparently it was lost somewhere in the system. Mr. Crawford pulled this and sent it up, so it might not be our final, might be a working copy.
This one was received actually yesterday, the 13th,
Right.
is what we have presented.
Correct. That was requested over the weekend to finalize the paperwork. Again, we're going to be going with that price. If the math doesn't add up, it's going to be an administrative task for us to change that. But the final price is going to be looking at the $695.
How do y'all handle that, Mr. Gribble, to ensure that that is correct?
What happened was whenever the inspector went and did the inspection, and was scanning documents. And remember, there are multiple pages. Evidently, the second page of the price list was failed to get scanned in. So when Mr. Bohannon sent the information out to the board members, and one of the board members contacted me and said, all the price list doesn't seem to be there. So I went back and looked through our documents, and we did not seem to have that. So then I contacted Mr. Ray over the weekend. He was out of town with a family event, and he contacted Mr. Crawford. My understanding, Mr. Crawford then sent me a general price list Saturday or Sunday, real soon after I asked for it. And that's the general price list that he sent to me. But the inspector, when they do the inspections, they check the price list to make sure that, I mean, they can make an error, they can make a mistake, but I mean, they check the things to make sure that it's compliant with the funeral rule.
So there's a final inspection before the business is actually opened, or this is what they've submitted, so this is what we'd be going on.
So, this particular situation, I would say that the inspector did the inspection and noted no violations to us. When we did not have the price list, the second page of the price list in our documents, then we requested it and they furnished it. And again, it could, as Mr. Ray says, it could be but I mean, I'm sure they probably more than likely be willing to look at it, send us a final version. I can let the inspector look at it, before we, assuming the board, wants to approve the application, I can let the inspector look at it in review of the funeral rule before we issue the license.
It could be subject to receiving an updated GPL that's correct.
Let me be clear. They didn't fail to furnish it at the time.
Right.
It was when we were scanning, when the inspector scanned the documents in, evidently the scanner pulled 2 pages at once, and that's why we went back and asked for it at the late notice.
That's what we're looking at, the most recent one, and I guess the numbers don't add up is what we're concerned about.
Draft that I had in a folder. Ray had his on his computer, but he was out of town. More likely, I had an incorrect draft.
Mr. Gribble, this might be a question for you too. On the application B4, transfer of remains to funeral home, it's marked yes and no under the acceptable portion. Is there maybe a reason why this is?
I can't speak for the inspector, so I'm unsure as why both of them are checked. But I went to look at notes. There's nothing in the remarks that would indicate that there's a problem there, and there's obviously no notice of violation was written or anything at the time of the inspection.
Thank you.
For clarification on the GPL, like on a package where you've got the blue cremation package and the amount there, and then you got a description. Does a package have to have that itemized out on the components on the GPL, or can you just state the package because they're not in the price? No, okay, I wasn't 100%.
It's me again. On your casket price list, you have one offering, and may I call you Mr. Ray because I don't think I could say your last name? Okay. So if I'm looking at your GPL and I say, oh gosh, I don't want Daddy cremated in a cardboard box, do you have other offerings, or is this a $25 cardboard
At this time, it's our plan just to have the one offering. Again, we will see determined based on consumer requests. If we feel that's something that people are looking for, asking about, we'll be able to add that on and adjust our price list. But right now, going into it, we're starting with just a plain alternative container.
Will you be offering urns?
Yes.
Does that have to be in the GP? Urn pricing?
Or the GPL has to refer to and say there's a separate urn price
I didn't
list.
see anything about the
They're
urn
saying a
price
list will be provided at the funeral home. There's a
Up here
price
at the top of
range,
the
but
last- up-
second page.
List will be.
Which funeral home?
Cremation company. That's general one on the front of the general prices will be consistent with that.
Kind of gets confusing. Funeral home or cremation company or so. Actually, establishment. So a funeral establishment, but covers cremation. So
The public
Yeah.
wouldn't.
Right. I may be incorrect, and forgive me if I am, but isn't that wording compelled by Federal Trade Commission for the general prices that it has to say that the list will be provided by the funeral home?
I don't know, but on my GPL, it's a listing of our urns that we offer, total listing. But I don't know if that's
Yeah,
required.
That does too.
yeah, I don't know if FTC's guidelines say it has the exact word funeral home or not.
Or a listing of urns.
It's just kind of confusing. If it,
We have a separate urn price list. This was not requested by the board, so we didn't submit it. But it is available, and will be also.
Would the cremation company offer identification?
I ma'am, no. And again, they would be referred to our sister funeral home for that. That was determined in the process.
So will you personally be going to do the identification yourself as the director with a picture, or who's going to be responsible for making that proper identification?
And depending on where the death takes place, if it's at a residence with family there, we'll establish identification at that point, placing identification bands on. Otherwise, we'll be asking for a recent picture or again any unique characteristics of the remain body that we could use to help identify.
So to go back to my question, if you ask for a picture or markings, you're at your location. Are you personally going to be the one to go make that identification, or are you going to lean on your sister company to do that for you?
That's not something I've contemplated. It would be one of the two. If it's my responsibility, it would be me. But again, it would be someone in our company.
Bodies, we don't. So when we make removals, our personnel, like Ray indicated, many of the for the
just a note, going back to that GPL. So I assume if you're almost going to have to be able to present both GPLs then to a family. If you start talking about identification or viewing or that type of thing.
I just may address the board briefly on that. For the last 3 years, I've been working in Charleston, South Carolina, as the managing partner for a group called Palmetto Cremation Society, which is owned by Mark Smith, who also owns 6 traditional funeral homes in the Charleston area. And if people called us, asked, and we provided simple cremation services, just as we're contemplating here. If someone called and requested, if we determined even early on or even at the very beginning, but not necessarily, where they were requesting services that we were not able to provide, that were not part of our offerings, we would give them the option of using one of our sister funeral homes who could do that. At that point, the family in the case would be transferred to one of those funeral homes, and they would handle it from then on. We would be finished with it, and now be transferred to that funeral home. That funeral home would be handling the case because it was more in line with what they were asking.
So your personnel would basically respond, we're not going to be able to speak to you about the pricing of what the viewing is. We'll refer you to our sister funeral home to get that information. Because if you started discussing what that pricing is and things, you would need to be presenting that GPL for that funeral home. So that is, again, to me, that's a little burdensome on the consumer on how you're going to handle that.
All I could say, Mr. Berry, is based on operating a 600 case a year plus cremation business, that happened maybe once every other month or so, and it was a seamless transition. The family was actually pleased we were able to do that, and it actually goes pretty smooth. It's just, again, it's like anything, it's how it's done. And so I had great success with that, and don't expect anything different here.
Saying out of that volume level of 600, you would only have 1 or 2 families that would actually request to see their loved one.
Correct.
Mr. Crawford, I'm new to the board, and is this concept the first one in Tennessee of the online offerings?
Oh, no. I think the difference with the way we're going to operate it is being supported by a back office service that we own, not being farmed out to a third party. That's about the really only difference. It's not a true expansion of the funeral home, because even though we're owned by the same company, we have no interactions between the two. It's not like a trade-off between one or the other. But no, this goes back. I mentioned to Robert before the meeting, Al Tacker. This really, the genesis of this goes back to the 50s, when funeral homes wanted to have a chapel without an embalming room in it. The way they did that was say you have to have access to embalming facilities. Okay, that opened the door for the storefronts, and that started with Al Tacker in Memphis, and he had the casket store, then he had a storefront. And now we have, Parkline owns 4 of them here in Nashville. And some of these things are supported by in-house equipment and personnel from their ownership, and some are farmed out through a trade service. And you got one trade service supporting how many of these things? So the concept isn't new. And as I pointed out in my initial narrative, it's 1978, no crematories in Nashville. 1998, I'm getting my own. And I can remember getting phone calls from colleagues. Why are you promoting this? Why are you making this cremation thing more popular than it should be? And I said, it's not a matter of promoting anything. This is where the consumer's going. This is what they want. So some of these changes have come about, and this is more a reaction on our part to try and conform with what the consumer's asking for. And from an operational perspective, it's virtually impossible to run a machine and a building and a funeral home and do cremations for $900.
And I understand your point of other companies are doing that in Tennessee, but I don't know of other companies that are not having full offerings, meaning embalming is available, more than a cardboard box is available. I've not heard of that concept, is what my point was. I know that other cremation societies, other cremation standalones, they have to outsource a lot of what they do. But I may be the only one on this board, but I've not heard of anyone not giving full offerings and if some people don't know that a wooden casket for cremation is something that could be available. The consumer is not always educated, but yet they need to be educated. And I think this brings down the value of offerings that other places in all over the country has. So I'm not familiar with the concept. That doesn't mean it's right or wrong. I'm just not familiar with it.
Well, Ms. Stevens, a lot of this comes from my operational experience. In 1998, when I put that crematory in, Batesville had come out with a line of cremation caskets. I never showed one. I mentioned it to consumers many times. Now I got the response, the same response every time. What's different about that container compared to any other casket? Does it burn different? No. It was just called a cremation casket. And I think that the attempt on the part of the industry was to merchandise cremation, because obviously we make money off of our merchandise. So what I have found is 20 so many years of cremating people, never sold a cremation casket. Offered it, but never sold it. It's not something that's been popular. And when Ray and I were talking about this a year ago, I likened it to, if you've seen the commercial for WeatherTech. When I first saw this WeatherTech product, I thought, these guys aren't going to make it. They're selling floor mats, for God's sake. But look at what they do now. They sell cup holders, they sell seat covers, they sell this, that, and the other. So we wanted to take this from a ground level opportunity to address the consumer that's cremation oriented. And then as they grow in their requests, we can grow with them. We have the capacity for that. It's just that starting out here, we don't want to offer a whole bunch of things that we know they're not going to want. And that comes from, all these years of operating my own crematory with the public. This is not coming from studies or anything else. This is just experience.
I don't care whether or not you've sold a casket or not. My point is the offering, and I'm going to stick with that. That's my point.
And I think you just made the answer that what Ms. Stevens was getting to. How do you know they don't want that? If it's not offered and it's not showed to them, how do they know?
I'll address that anecdotally from my experience, again, going back to Charleston and get it to loose comparison. But again, for the last 3 years with that 600 plus call firm, we showed a full line of alternative containers through regular traditional caskets on our website, on the price list in our presentations. And maybe once every other month, someone asked, it's agreed for something else. So again, a very small percentage of take upon a request for that.
Any other board members have questions? Anyone want to make a motion that this establishment be approved, or make a motion for other things to be brought back for us?
Only questions I had, Mr. Harris, you pretty much answered them, and Mr. Gribble, as far as the discrepancies I saw on the GPL there. But other than concern, is there anything that prevents them from getting their establishment license today?
That's based on us approving with what's presented, if I'm not correct, Mr. Gribble. That's them getting their establishment would be based on us approving what we've been presented.
They're discussing that. Remind me again what the requirement is for signage. There does not have to be, or there has to be some signage on the outside.
I thought the other ones we had to have signage. The other ones we've approved will.
Is there any
ask that as
signage
well.
outside of the building, or is it just y'all? I think mentioned something about when you walk in the door, there's a directory, but is there signage outside?
So it's
Inside the building, though.
So there's nothing at the road or on the front of the building.
Does that meet the minimal requirement, Mr. Gruber?
I think so. There are other establishments that are the same way. I can tell you that. There are others that exist that are inside an office complex to where when you walk in the door, you see a
That's what it's-
directory.
okay.
Like you do when you go to the hospital, you see the doctor's names listed, and then when you get to the floor or whatever, then outside that suite, you'll see the doctor's name. And there are others that are like that. My knowledge, the rules doesn't specifically require a sign that's visible from the outside of the building.
Thanks for clarifying that. Based upon the investigators and I guess the staff, all the minimal requirements are being met.
That's correct. Whereas the inspector and the staff, we know of no reason that there's no statute or rule that we can refer to where there's not been a check mark.
Both gentlemen, I still have the concern for the consumer, but our hands are tied, and if you meet all the criteria, then I mean, we're going to have to do what we have to do. But again, the consumer is my concern.
And where do we stand on the inconsistency of the GPL? Is that where they represent it to you before a license is given, or?
That's okay with the board if that's, they could send their latest version, and then I'll get one of the inspectors to look at it, sign off on it before we issue the license.
Other questions? Entertain a motion if anyone wants to make that.
I'll make the motion.
Motion is to approve as presented. Okay. Have a motion by Mr. Porch to present for approval of the establishment as presented. Do we have a second?
I'll second.
We have a second by Ms. Haynes. Any further questions or discussion? If not, all in favor, say aye.
Aye.
Any opposed would be aye.
Congratulations.
All right. Any other establishments, Mr. Gribble?
No, sir, that's all.
All right. We'll open the floor for any new business that anyone has. If there is no new business, we will entertain motion to adjourn.
So move.
All right. Multiple motions by Mr. Berry, Mr. Lee at 11:53. This board is adjourned. Do we have a second? All in favor? Aye.